Hi, I'm Bob DeLamartre, one of the instructors for INS23. Today we're going to try something a little different. We're going to look at Chapter 8, Commercial General Liability Insurance, and rather than taking a very scripted, typical approach to this video, I'm going to try something a little different. One of the things that some of our students have said is that they like live courses from the standpoint that you have the impromptu aspect of the instructor, the professor in the course, whereas with asynchronous courses you have more of a canned approach. Well, obviously asynchronous courses work much better for most folks nowadays because they don't have to manipulate their schedules to match up with the course schedule. They have the liberty of accessing the course whenever they want. But with this video, I'm going to try something a little bit different. I'm going to call this Reality Asynchronous Education. What I'm going to do is I'm going to discuss with you some of the aspects of commercial general liability, criminal law versus civil law, the basis for legal liability, contracts, statutes, and liability insurance. But I'm going to do so as if we were talking live. In other words, I have not scripted this. This has not been rehearsed. So wish me luck. First of all, legal liability. It's really a fascinating subject because it affects everyone as far as their own personal lives are concerned, as well as organizations. Any company has legal liability exposures. This is their third-party exposure. And if we're going to look in the book, let's see what the book has to say here. It says that liability exposures are a legally enforceable obligation of a person or an organization to pay a sum of money, and this of course is called damages. You oftentimes will hear something in reference to a civil case where the plaintiff is suing the defendant for damages. Well, this is the sum of money, and they're an obligation to pay another person or organization. Well, what does that really mean? Well, let's say, for instance, that you are a store owner, and through a little bit of negligence on your own, you have a torn carpet. Well, this torn carpet is obviously a tripping hazard, and if one of your patrons comes in, trips, and falls and hurts themselves, you can be sued for damages or a sum of money in a court of law. Now, here we have some children in the neighborhood. I guess this is part of reality video, asynchronous video. In any regard, let's talk about civil law versus criminal law. Now, civil law is the branch of law that helps people settle differences between two parties in a civil case. Now, criminal law, of course, is a branch of law which imposes penalties on wrongdoers in society. But you see, they're two completely different branches of law. Commercial general liability or legal liability has to do strictly with the civil law side of things, not the criminal law. There are several different bases for legal liability, and that includes negligence, intentional torts, and strict liability torts. Torts are, of course, a civil wrong other than a breach of contract. Now, negligence. If you are negligent, like the store owner who I just gave an example of with a torn piece of carpeting, then you can be held responsible in case someone gets injured. If you are negligent when driving, or if, say, a company is driving one of their trucks and they rear end someone who is legally stopped at a stop sign, they could obviously be held liable under negligence. Negligence can take on all sorts of different connotations. Okay, intentional torts. Now, intentional torts include such things as libel and slander, invasion of privacy, wrongful eviction, that sort of thing. Libel and slander, of course, are main considerations. Libel being written words which harm a person, their reputation, cost them their ability to earn a living, cost them the opportunity to make a go of it in business, such. Whereas slander is a spoken word. You're trying to remember the difference between libel and slander. Slander and spoken both start with S. It's one of the easier ways to remember it. In any regard, strict liability torts are really one of the more interesting cases. Now, strict liability can occur in cases such as, let's say you are a blasting company. You know, you loosen up the stones and sides of cliffs so they can put highways through, or you are putting in a new foundation for a large building that's going up, and so you use blasting of dynamite and such to get things started. Well, as a blasting contractor, you have strict liability, you have absolute liability. All a person has to show is that this could possibly be from your operations. Let's say that you are blasting in a business park, and a building a block away gets some broken windows. Well, maybe you took every precaution that could possibly be thought of as far as doing your blasting operation. So in other words, you are not negligent. It's important to think about this. You're not negligent, or you don't have to be proven negligent to be held responsible under strict liability. But because your operation involves something which is inherently dangerous, then you can be held under strict liability with no negligence having to be proven in a court of law to find you legally liable. Another good case is, of course, if your company decides to have a mascot. Let's say that you are the Tiger Oil Company, and you think it'd be kind of cute to have a tiger as a mascot, so you keep a tiger penned up in the back of your building just for publicity shots and advertising, and also as just a little point of interest. Well, even though you've kept that tiger in a strictly perfect cage and kept them away, kept it away from potentially interacting with people, if someone hops over the gate, or the railing which you have separating from the cage, sticks their hand in, and the tiger does serious damage to the individual, well, the fact that you had an inherently dangerous animal, obviously a tiger is inherently dangerous, it's also an attractive nuisance, you could be held liable even though you were not negligent. So under strict liability torts, you really have that additional exposure.